Good day, everyone, and welcome to today's King versus Burwell Decision Day teleconference presented by Alston Bird. Just as a reminder, today's call is being recorded. I would now like to turn the call over to Colin Roskey. Please go ahead.
Thank you. I'm Colin Roskey, a partner in the Healthcare Public Policy Group here at Alston Bird, and we thought for the next 45 minutes or so we'd take an opportunity to listen to some of our colleagues and friends from our firm discuss the implications of today's decision handed down at 10:08 this morning that affirmed insurance subsidies for individuals in all 50 states. If time allows, we'll open up the phone lines for questions from all the listeners, too. As all of you know, this is the second time in 3 years that the ACA has survived a showdown in the Supreme Court. In 2012, Chief Justice Roberts, writing for the majority, declared that the individual mandate was a tax and essentially saved the ACA from unwinding. In this year's case, challenging the legality of subsidies in federal exchanges, Chief Justice John Roberts, again, this time joined by Justices Kennedy, Breyer, Ginsburg, Kagan, Sotomayor, sided with the Obama administration and said that subsidies in 34 federal exchange states were legal and asserted that the ACA was created to, quote, improve health insurance markets, not destroy them, end quote. Justices Scalia, Alito, and Thomas in this case dissented and asserted that the majority relied on, quote, interpretive somersaults to reach its decision. Speakers on our call this afternoon will address some of those alleged somersaults and discuss their implications for administrative law and for future challenges to agency action. But first, I want to turn to our colleague Tom Scully, former Medicare administrator and health advisor to two presidents, for his take on today's decision. Tom.
That's a great way to start. We're going to have our experts talk, but first let's turn to Tom Scully, washed up former bureaucrat. I'm kidding. No, I think the biggest, so I'm going to briefly cover the political news, a little bit of investor reaction to this too. I know generally I think this has largely become a political non-event, and I think we'll probably spend a lot more time talking about the legal impacts today. I think had the court gone against the administration, there would have been much greater implications, obviously. I think generally Democrats are excited because the ACA is going to go forward, and I think there'll be a lot of screaming and yelling the next year and a half from Republicans about repealing it for presidential election purposes and other purposes. The Democrats should be happy because their bill was protected, but the reality is an awful lot of relieved Republicans. I think had the court gone against the administration, the Republicans would have had a large mess on their hands, and it largely would have been a mess in the core southern states that they really know how to deal with. So I think the exchange meltdown there would have been ugly, and so I think Democrats are happy, and probably an awful lot of Republicans, including me, are happy this worked out this way because it kind of avoided a political meltdown. So I think the issue will remain a hot political issue through the presidential election, but I think it's very unlikely anything of significance is going to happen in Congress to change this thing in any way, shape, or form. And I think personally, the Democrats will probably perceive it to be a big victory. I think an awful lot of people in Republican leadership think this is a disaster avoided, and that's certainly the way I perceive it. The markets, and I'm also a partner in a private equity firm part-time in New York. The ACA has been great for you if you're an investor in healthcare. It's been a massive influx of the capital and coverage. Dropping it would have been, the administration losing would have been a real disaster for many people. I think most of the hospital stocks were slightly artificially suppressed until today. Most of them popped up pretty significantly today on the news of the ACA being protected. HMO stocks were all over the board anyway from the beginning due to the merger rumors this week, but virtually every healthcare stock went up today, and essentially I think it's a huge relief for healthcare investors. And it's, my firm happens to be the biggest private equity health investor, and I can tell you we were very happy with the result. So I think politically it's much more of a non-event as a result of the administration prevailing than it would have been had it gone the other way. I think the waters will calm a lot politically outside of the presidential rhetoric, and I think it will be perceived as a victory for Democrats, and it certainly is. But I think there are just as many Republicans breathing a sigh of relief that it turned out this way. And, I think we're going to avoid a lot of fights that would have made the next year and a half unhappy, and they'll largely go back to the presidential level. Secretary Clinton saying the bill's good, and Republicans all saying, or most of them saying, should be repealed. So that's a quick overview. From an investor point of view, it's absolutely positively all positive. There's no downside to it, and I think you'll continue to see the healthcare stocks probably run for a little longer out of this. So is that a quick summary, Colin? Now you can move on to your experts.
Thanks, Tom. No, we appreciate that.
Sure. Okay.
Thanks. We'll pivot now to our partner, Dan Jarcho. Dan is a partner in our litigation and trial practice group, and he specializes in administrative procedure in cases brought against federal agencies. Dan formerly worked at the Justice Department as both a senior trial attorney in D.C. and a special assistant in the Eastern District of New York. Dan, can you help us walk through the thinking and the logic of the majority opinion and maybe the implications for future litigation against the government?
Sure, I'd be happy to. The opinion really starts with a history lesson about the situation that led Congress to act in enacting the Affordable Care Act. And it goes back 20 years to the 1990s when the states were experimenting with expanding coverage, specifically talks about Washington and New York. And the court talks about the guaranteed issue concept, which is the concept that an insurance company can't deny coverage, and the community rating concept, the concept that the insurance company could not charge higher premiums based on the health condition of the insured. And the experience of the states back then was that if that was the only part of the program, it actually had a counterproductive effect because patients would wait until they got sick to be insured. They were guaranteed that they would be covered and their premiums would not go up. And the result was that the number of uninsured actually increased and prices of premiums dramatically increased as well. And that was the backdrop for the Affordable Care Act. And as the Supreme Court emphasized, the Congress had the state law concept of guaranteed issue and community rating, but added to it two other key elements which had been developed initially in Massachusetts. In addition to the guaranteed issue and community rating, the second element was an individual mandate that people would need to have insurance. Critical for the court's decision was the fact that there was an exemption from that mandate if people couldn't afford it, and it was defined in terms of insurance costing more than 8% of someone's income. The third element the Supreme Court identified in the Affordable Care Act was the tax credit subsidy that would be given to people under a certain income level in order to help them pay for the mandated health insurance. The court emphasized that the three elements were intertwined with each other in that if the subsidy wasn't there, many people would be spending too high a percentage of their income on insurance and therefore would be exempt from the individual mandate, and if they were exempt from the individual mandate, it would lead to the same sorts of problems that the states had previously experienced when they only had the guaranteed issue and community rating. The term that has been used a lot to describe this situation is the death spiral, that you'd have ever-increasing costs and ever-decreasing coverage. The key to the Burwell case relates to these key subsidies and the people who are entitled to them, and in particular some language in the statute that says that the subsidies will be available for insurance purchase, quote, on an exchange established by the state. Now, there are both state and federal exchanges. The statute allows states to set up exchanges, and if states choose not to, the federal government comes in and sets one up on their behalf. And as things have shaken out in the aftermath of the statute, 34 states have federally established exchanges and the remainder established by the state. So the question that the court was confronting was, do the subsidies extend only to those state exchanges or also to the ones that are the federal exchanges, essentially exchanges established by the federal government on behalf of the state? If that's true, there would be subsidies everywhere, and if not, there would be no subsidies in the 34 states with the federal exchanges. The court emphasized that 87% of the people who bought insurance on the federal exchanges bought them with subsidies, so this would have a huge impact, and the court thought a death spiral in the majority of states. In order to sort this out, the court focused on the interpretation of those 4 words established by the state, and the whole case really turned on the meaning of those 4 words. And the parties' different views on that were a literalist interpretation, ultimately adopted by the dissent, saying they mean what they say. If it's established by the state, it means the subsidies are only available in the state exchanges, not in the federal exchanges. And the other view, which was adopted by the majority, was a contextual approach to look at the overall history, context, and a number of related statutory provisions to interpret a different way, to say that Congress intended universal subsidies because it intended relatively universal coverage. The court, in particular, went back to the 3 elements that I mentioned and focused heavily on the fact that if the challengers were correct, we would have a death spiral in the majority of states. That couldn't have been what Congress meant, they thought. And one quote from the opinion is, we cannot interpret federal statutes to negate their own stated purposes. The court's view was that the 3 elements that I mentioned to begin with are so essential to the purpose of the statute that it simply couldn't mean what the challengers said it meant. The dissent focused very much on the 4 words in isolation, a literal interpretation of them, tried to support that with various other statutory terms. Quote from the dissent is, even the most formidable argument concerning the statute's purposes could not overcome the clarity of the statute's text. The dissenters said that the surest sign of what Congress intended was the express language of the statute. They meant what they said, and in their view, that was sort of the end of the matter. I think from my perspective as an administrative law litigator, there are some significant implications coming out of this case for purposes of other statutes and potentially other federal administrative agencies. Under the rubric of administrative law comes the set of legal rules that courts apply when they interpret statutes, and this was a interpretation of 4 statutory terms that led to this significant case. And one of the core questions of administrative law is, what are the interpretive rules that courts follow when interpreting a statute's text, and how should they be applied? It's not surprising that there are many rules and competing rules depending on how they're applied. But one of the central doctrines that is ordinarily applied in a context like this, where you have a statute being interpreted by a federal agency, is the famous Chevron test, which is a 2-part test that essentially says that if the statute is clear, the court interprets the statute without regard to the agency's interpretation. But if it's ambiguous, generally speaking, the court must defer to the agency, which in many cases or most cases means that the agency's interpretation prevails, because the standard is that the agency's interpretation is affirmed as long as it's reasonable. The court doesn't have to agree that it's the best interpretation, but only that it's a reasonable one. And since most federal agencies operate in reasonable fashion, that's a very difficult standard for challengers to meet. In the lower court, in the Fourth Circuit, the court held that the statute was ambiguous. It had a very straightforward application of these typical Chevron principles, relying in part on a case that I had litigated in the Fourth Circuit. But the striking thing that, in my view, is evident in the Supreme Court's decision is that the court said, here the statute is ambiguous, but they are not applying the normal Chevron rules. And this is quite an unusual situation. The rationale for not following the ordinary rules relates back to the roots of Chevron and the deference doctrine and the principles underpinning it. And those principles justify deference to an agency on the ground that if Congress enacted an ambiguous term in a statute, it implicitly delegated to the agency the authority to fill gaps and clarify the ambiguities. And so for that reason, within reason, the agency's interpretation should prevail. Here, the court said that although the statute was ambiguous, this was such a central aspect of the statute that they did not believe that Congress would have delegated to an agency the responsibility and authority to fill gaps and answer this critical question, particularly not the IRS, which is the agency that promulgated the regulation under challenge, which has nothing to do in the ordinary sense in regulating healthcare matters. It could have been a different situation if HHS had been the agency at issue. I think the interesting thing from my perspective is that the majority came out in the same place that it would have come to if it had deferred. If it had deferred, it would have said that the administration's regulation is a reasonable interpretation of the statute, and it's affirmed for that reason. Here they said we're not deferring, but we reached the same conclusion on our own. And so I think, while the failure to follow Chevron didn't have important significance in this case, it well could have important significance in other cases involving ambiguous statutes in which courts say, I'm not going to follow the normal Chevron rule and defer the agency's interpretation. I'm going to take a fresh look at this. And another way of saying it would be that plaintiffs challenging agency actions might have a little bit of ammunition out of this case to better challenge an agency interpretation. And so in that sense, this case could have very broad application to any statute administered by any administrative agency. Another big picture way of looking at it is that in a sense there's been a little bit of an enlargement of the judicial branch's role vis-a-vis the executive branch's role. Instead of deferring to the executive branch in an interpretation of a statute it's charged with administering, the court is instead going to take the front lead role and not defer. In fact, the opinion doesn't really refer to the IRS interpretation at all. It just jumps right in as if there had been no agency interpretation. So that, in sum, the comments I've been making at the end here are the implications that I see, potential implications for future litigation.
Thank you, Dan. Those are some, I think, very interesting perspectives looking forward from beyond King versus Burwell and all of the politics of the Affordable Care Act toward the future of stakeholder entities that are challenging federal agency action and what the role of the precedent in this case will be going forward. Turning back to the perspective of somebody who was in Congress and who was involved in the construction and evolution of the Affordable Care Act, I want to turn to Congressman Earl Pomeroy, an 18-year veteran of the Democratic Caucus and a member of the Ways and Means Committee on our team here at Alston Bird, to share your thoughts on the outcome today following this morning's decision.
Thanks, Colin. As I read the opinion, I wasn't thinking about my time in Congress. I was thinking about my time as a state regulator. 8 years before coming to Congress, I was an insurance commissioner. And this is an opinion an insurance commissioner has to love. It's all about how health markets work. And so it was a very interesting and clearly written opinion in that regard. Anyone who's seen anyone from the president through the cast of characters that passed the law, count me in on that one, try to explain what's in this thing and how it works, it's just been torture. It was too complicated to explain. If you can't explain it, you can't defend it. And that's really in large part why the Democrats have had so much difficulty. So I want to read to you just a line from the opinion which is, I think, reflective of the incredible clarity in the writing on this opinion that laid out the law in ways that I wish we'd have had Justice Roberts helping us with messaging in terms of just trying to explain how this thing is supposed to work. I read, the guarantee issue and community rating requirements ensure that anyone can buy insurance. The coverage requirement creates an incentive for people to do so before they get sick. And the tax credits, it is hoped, make insurance more affordable. I have spent no small amount of time trying to explain how this thing works, and I never did get to that level of clarity. I think that the law is, the ruling is extremely well written in that regard. And here's the policy things that I see coming out of this opinion. The court is not going to end or substantially rework the Affordable Care Act. It upheld the constitutionality before, and in a case that many of us never thought would push us once again to the edge of wondering if the law would be intact after the Supreme Court ruling was announced, it has been interpreted as statutory intent is consistent with how the administration has been implementing the Act. Second, that means that in order to be substantial changes, they're not going to come from the court. They're going to have to come from the legislative branch itself. And because the legislative, under the Constitution, the legislative branch interacts with the executive branch in the enactment of laws, and we do have divided government, there will not be substantial legislative altering of this law with a successfully enacted statute that becomes law, at least until 2017. What I think that creates maybe is the third policy takeaway, and this is, call me maybe the last optimistic guy in town, but I'd like to think we took a big step forward as a country today to getting past this non-constructive standoff of repeal the law or defend every hair on its little head to a point where we can begin to talk thoughtfully, maybe even across the partisan chasm, about those parts that need to be revisited and addressed. The court makes reference to they say it politely, but numerous instances of inartful wording in the Act, and they talk about also the process by which it passed in budget reconciliation, not getting the conference committee. This Act could use a more thoughtful, deliberative, and bipartisan approach at addressing problems in the Act. I've said many times no Act ever needed a technical corrections bill more than this one, but we've not been able to do that in this kill it, save it standoff that we've been in. I think maybe we move past that today. The politics. How do the politics come out of this? Well, on a policy perspective, I think clearly big win for the Democrats. The Affordable Care Act is the law of the land. Again, subject to change, maybe subject to evisceration down the road, but right for today, it won't happen in the Supreme Court building. It's the law of the land. That's the policy win. But I agree with Brother Scully that maybe the political win coming out of today inures principally to the Republican Party. How in the world could that be? Well, what I have found in politics is that health care is very, very ripe material for effective political campaign ads and strategies. And they work the best when people feel threatened. In other words, the party, the politics with health care generally rewards the status quo. It punishes the party that creates uncertainty about health care. And I believe that now with the Affordable Care Act upheld, that's the law of the land. So the Republicans can rail about it, this and that, but it's rhetorical, and it's policy ideas. People have not just had their coverage ripped out from underneath them, and we don't have utter chaos with the impending doom of the individual insurance marketplaces in the 50 states. That would have created a chaotic, very uncertain environment, and I think it would have been held against the Republican Party in the upcoming election. They're spared that, and I think that therefore means they didn't embrace the political risk that would have come to them had suddenly the landscape changed that dramatically. So, all said, as one who voted for the bill, find myself in the private sector, probably in no coincidental relationship to that vote. I think it was an appropriate result by the court. Admittedly, I had a favorable view of the law as I read this opinion, so that affects my view of it. As a member of the former member of the legislative branch, I like what Dan has said about the administrative law implications of this. I think the Chevron case itself might have given even more authority to these unaccountable administrative agencies, and I think that it was reined back a little potentially in this case, particularly where it's found that the core question of the statute clearly had to be a matter that Congress had an intention on, and agencies will be a little more limited in their ability to rewrite congressional intent. So I kind of like that aspect that might flow from this act as well. Colin, that's my overview.
Thank you. Thank you, Earl. I want to switch gears in a little bit of our time remaining here and ask my colleague Dan Taylor, counsel in the Employee Benefits and Executive Compensation Group in our Atlanta office, to provide any practical advice, any practical takeaways in their thinking from Dan from the decision today.
All right, thanks. So, by way of a little bit of background, the employer mandate imposes potential excise taxes on employers if a full-time employee goes out and purchases subsidized coverage on the exchange. So the tax subsidies were very important in determining the exposure that employers may have to those excise taxes. Obviously, the more exchanges there are, if they're in all 50 states, then it's more likely that an employee will go out and purchase subsidized coverage. So with the decision today, really we just remain status quo. So most employers have been gearing up, expecting that subsidies will be available on all exchanges. That hasn't changed as a result of this opinion. So employers should proceed with the actions they've been taking to prepare. Also coming up in January will be the first round of reporting that's associated with the employer mandate. That applies to all months in 2015, even if employers not subject to the excise taxes for all 12 months. So again, employers need to move. There may be employers who are regional or state specific where their business footprint was limited to states with a federal exchange that may have delayed preparing for either the excise taxes and the actual employer mandate or the reporting associated with it. Those employers will need to take action quickly to get up to speed. In addition, there are employers that may have plan years that begin later in 2015. They get some transition relief, and they may have also been waiting to gear up based on how this ruling came out. Those employers will also need to begin in earnest, if they have not already, to get prepared for the reporting and all the administrative process that needs to be in place to comply with the statutory requirements. So the bottom line, though, is status quo. Employers should continue to do what they've been doing for the most part. And there are a discussion of what all those compliance requirements are is really beyond the scope of this. There will be a link in the advisory that we'll put out in conjunction with this call that will help you to find additional material that can help you with compliance questions related to the employer mandate.
Thank you, Dan. And to Dan's point about the advisory, if you are on the Alston Bird mailing list, you will be receiving shortly, probably within the next day or so, if not sooner, a comprehensive summary and analysis of the decision today, along with other tools and resources, like Dan mentioned, to help you think about going forward. We do have some extra time here in our afternoon if there are questions. So I want to turn to our operator and ask her to open up the line if there are folks who want to address our panel of folks this morning or this afternoon from Alston and Bird. And in particular, though, when you do speak, to not identify yourself, as there are media on the call, and we'd like to preserve your anonymity as much as possible.
Thank you. And we'll go to our first caller. Please go ahead.
Hi, I have a quick question. Today, during the President's remarks, he mentioned if you're a senior, this law gives you discounts on your prescriptions, something that has saved 9 million Americans an average of $1,600 so far. What exactly is he referring to when he says that?
My guess he's referring to the part of the law that is incrementally filling the so-called donut hole with the prescription drug coverage. One of the features added to the law that really hasn't gotten a lot of conversation in the midst of all the other parts was the fulfilling the commitment to fill the donut hole. That was the period of, that was the area where the coverage ended under the originally passed prescription drug coverage, and I think that's what he's referring to.
Right, the Part D coverage gap, sometimes called the donut hole, as part of the agreements that were made between industry and Congress in the ACA. There was an agreement to gradually fill in, that is, to subsidize the cost of drugs that beneficiaries would need while they were in the coverage gap. So that's what the President's reference was to.
Thank you.
And once again, that is star then one for questions. We'll go to our next caller. Please go ahead.
Yes, good afternoon. I was just wanting to check on the results of King versus Burwell on the many other ACA cases that remain outstanding.
That's a good question. We actually just had a short conversation about that before getting started. So we know that there are still probably smaller issue but still important ACA challenges throughout the country, some of which are directly related to the family of King versus Burwell cases, and some of which are not. I'll ask Dan to comment on any of the lower court cases that are similar to the theories that are advanced in King, and then I'll get to the other cases.
What will happen in those cases, for example, the D.C. Circuit case that had created the conflict that led to the granting of cert, would be that the courts will reconsider their earlier decisions in light of the new decision, and as a practical matter, the very same result will occur in all of those cases that essentially present the same question.
And separate from the subsidy legality question, there is likely to continue to be litigation against the statute, in particular areas that have attracted attention that we've already noted over the past few years have been challenges to the Independent Payment Advisory Board, challenges to the contraception mandate, challenges to the requirement that legislative branch employees own or purchase insurance on D.C. Exchange, or rather be waived out of it. So I think the continuing work to, around the edges, still change the statute is not going to go away. There are going to be opponents to the law that look for ways to chip away at features or elements of it that may not be as crucial or critical as the legality of subsidies in 34 states, but still notable when it comes to litigation against the statute.
No question about that, Colin. For example, the House Republican case that challenges the subsidies that flow back to the insurance companies participating in the exchange. Now, that's a very big business question to those insurance companies, but it really doesn't go to the fundamental pillars of the Act. House Republicans could win that case. Health insurers could take a hit on it. It would have consequential premium increase effects to the consumers. But the Act is going to stay intact. The premium subsidies would help those deal with those affordable provisions. And so, there are these other many points of attack. I'd like to think if we can get a process going where there's a little bipartisan participation in trying, maybe after the next election, address some of these issues, you're going to have things revert more to the legislative branch and not have this extraordinary circumstance of the House majority having to litigate in court. To me, that's just kind of warps one's notion of how the Constitution, how the division of powers, the checks and balances is supposed to be operating.
Anything further, caller?
No, thank you.
Thank you. And as a final reminder to the audience today, it is star then one. We'll move to our next question. Please go ahead.
Hi, I was wondering if you could give us an idea whether subsidies are actually living up to expectations.
It's a kind of political question. I'll take my shot at it. 87% of those covered in the exchanges have subsidies. I think the average something like $240 a month. And the role of the subsidy was the way I always tried to explain it was, this act, if you don't have, you can't get insurance because you're sick, well, you're going to be able to through the insurance reforms. If you can't get insurance because you can't afford it, well, there's going to be some help in making it affordable. Now, I think that going forward, you'll have people affording the coverage with the help of the subsidy, but their coverage has, leaves them with substantial co-pays or deductibles, and there's going to be a debate in the future about whether or not there's adequacy of coverage, or are people still going bankrupt even though they had a policy because they had this out-of-pocket exposure. So I think that that's a debate that is going to inevitably come. But for the fact that most of the people participating in the exchange coverage, several million of them, are doing so through the benefit of the premium subsidy, I'd say it's working for a good many.
And I would just add, not to be negative, but that I think there has been government oversight of subsidy application that has shown that there have been many instances where subsidies have been applied for and delivered or otherwise taken that later on were deemed to be too excessive and that individuals had to pay back. So the system by which individuals whose incomes may fluctuate and who apply for a subsidy and then subsequently have to reconcile or chew up that subsidy against a future change in their income creates oversight problems for the Internal Revenue Service that I think probably need more streamlining going forward. I know Congress is always looking at subsidy recaptures as a way to potentially finance other health care priorities. I think it's acknowledged that the system isn't perfect, but to Congressman Pomeroy's point, it is an essential element. Back to the majority's main point, it's a key ingredient in the totality of circumstances surrounding the goal of the Affordable Care Act and of universal coverage.
Thank you.
We'll go on to our next caller. Your line is open. Please go ahead.
Yes, thank you. You stated that the decision talked about the context of the act and the purposes of the act, and that surely they didn't mean to have an interpretation that was directly contrary. This was the majority ruling, directly contrary to the purposes of the act. In that line of reasoning, having not read the opinion, I'm wondering how much was all of the legislative history drawn upon for the decision, because interviews that I've seen with all the Senate Finance and House Ways and Means staffers and health policy staffers, none of them said it was ever contemplated that these subsidies would not apply to everyone. And even the Republicans involved said that that conversation never took place. So was that legislative history part of the reasoning of the court?
My own view is that fortunately not. They, because it's really too imprecise. You have a bunch of people saying after the fact what they meant at the time, that would be a very flimsy basis to really ascertain what intent was. Rather, they found intent through the entire context of the law and had it how it was supposed to work together. And I'm going to read to you a paragraph of the majority's opinion, which I think shows they constructed intent basically by analyzing how this act worked and the only way it could work. And that's upon which they found intent, which I think is a good basis to do it. I'll read you this paragraph. The section that provides that section provides that if the state elects not to establish an exchange, the Secretary shall establish and operate such exchange within the state. The whole point of that provision is to create a federal fallback in case the state chooses not to establish its own exchange. Contrary to the petitioner's argument, Congress did not believe it was offering the states a deal they would not refuse. It expressly addressed what would happen if a state did refuse the deal. why I highlighted that in my own reading of it is that was precisely what I saw as a member of the Health Subcommittee of the Ways and Means Committee. There was never any talk about, well, we're going to incent states and they'll not be able to risk, and then we'll have all these state exchanges. Not at all. It was the states can do it, or there'll be a federally facilitated exchange as an alternative in the event states don't do it. And that was the entire contemplation of the majority that passed that bill at that time.
I would add that there's precious little in what you would really call legislative history addressing this issue. And one of the interesting things about the majority opinion and the history lesson that I mentioned at the beginning of my comments is that history lesson doesn't come from the legislative history. It comes from amicus briefs and other sources that the court is drawing on. And they seem to be saying there are some aspects of this statute that are so fundamental and so obvious that they don't need to come from the legislative history. They're just, with all of the partisan divide on different issues, one thing that everybody knew was that the law was supposed to have these three elements, and this is the way they were supposed to work together. I think, when you talk about the implications of this in future cases, there may well be criticism of this decision in the sense it's not relying on what you would traditionally call legislative history. It's going out to some of these other sources, which ordinarily are not the kinds of things that judicial opinions rely on. But again, it kind of goes hand in hand with this notion of why they're not going to defer, that it was in their view so self-evident from the context, from reading the newspaper, if you will, the way this statute was supposed to work, that there couldn't be any reasonable doubt about some things.
Right. They draw legislative intent from basically their analysis of how health insurance markets function, right, and therefore what would be a rational policy approach at that health insurance marketplace, which again gets back to my opening comment. If you're an insurance commissioner, this is a really interesting read because I've never seen a Supreme Court ruling go into the details of how an insurance marketplace works like this one does.
But just to close that commentary, I think that is where the dissent finds its biggest source of outrage, is that the court assembled a view and a logic and a theory to support their decision based on a totality of intent from amicus briefs and elsewhere that is some of the gymnastics, at least, that Scalia referred to in his dissent, that I think will continue to provide fodder for House and Senate Republicans to continue to talk about this as SCOTUS care, which I guess is our new word of the day, coined by Justice Scalia. And so we'll have to listen for that. Again, around the edges, though I agree with others who spoke before me, this is largely an affirmation of a law now 5 years old and 2 times tested by the Supreme Court in relatively strong shape. So with that, we've come to the end of our time together, and I just wanted to appreciate and say thank you to all who dialed in and listened to us. If you have any follow-up questions, would like to speak to any of our attorneys and public policy advisors directly, you can reach out to us, whether it's about this case or the ACA more broadly. If you are on the mailing list, as I said earlier, you'll receive a summary and a legal analysis of the opinion shortly. It'll also be posted on our website, alston.com, within the next few hours. Thanks very much.
And that concludes today's conference. And again, we thank you all for joining us today.